We will begin the event by acknowledging that we are meeting on an Indigenous land that has been inhabited by Indigenous peoples from the beginning. As settlers, we are grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. I would like to acknowledge that living in the Ottawa-Gatineau region, I am on the unceded traditional territory of the Algonquin Anishinaabe people. I wish to also recognize that we all work in different locations. Therefore, you are probably working on different Indigenous lands. And I encourage you to take a moment to think about on which territory you are today. Thank you. IP Talks is the first collaboration of our recently launched IP Village initiative, which is helping teach Canadians and our clients how to navigate and use the IP ecosystem, and includes organizations that help build Canadian businesses. Our core partners are the Business Development Bank of Canada, the Global Affairs Canadian Trade Commissioner Services, Export Development Canada, the National Research Council's Industrial Research Assistant Program, the Intellectual Property Institute of Canada, the Department of Innovation, Science and Economic Development Canada, and of course, the Canadian Intellectual Property Office. So we know that it takes many people's help to build a successful business, and we are all here to help you every step of the way. Today's webinar is co-hosted by CIPO, Canadian Border Services Agency, and IPIC, and I'm so delighted to introduce today's speakers panel. So first we have Eve Heafy. Eve holds a master's degrees in chemistry and in law. She is a decision maker at the Trademarks Opposition Board at CIPO. Prior to that appointment, she practiced as a trademark lawyer. She has been a member of the Law Society of Ontario and of the Barreau du Québec since 2012 and 2013, respectively. Next, we have Marcel Brisebois, who joined CIPO in 2005 as a patent examiner in the biotechnology division. He's a graduate of the University of Sherbrooke, where he obtained a PhD in immunology. Marcel is currently a member of the Patent Appeal Board. We also have Anna Lynn Forrest, who has been with the Canada Border Services Agency since 2005, acquiring much of her foundational experience as a border services officer. She now brings this insight to her role as Senior Program Officer in the management of CBSA's Intellectual Property Rights Program. Lauren Lipkiss is a lawyer who is particularly known for effective anti-counterfeit enforcement. He was pivotal in working with the Canadian government to get more effective laws to protect us against counterfeit products. Lauren also works with expert forensic investigators, computer forensic specialists, e-discovery professionals, and others. Lauren gives training sessions across Canada and knows the ins and outs of the impact of counterfeiting. Finally, we have James Plotkin, who is an associate with Gowling WLG, practicing in the advocacy and intellectual property groups. His practice focuses on commercial litigation and arbitration, intellectual property litigation, and administrative law. He frequently acts in international and domestic arbitration. James is certified as a qualified arbitrator by the ADR Institute of Canada. And of course, my name is Meena Kushwaha, and I'm the director of CIPO's IP Awareness and Education Services. I am a scientist by training and have been involved in the IP space for over 15 years. Here at CIPO, we have a very keen interest in helping Canadians and their businesses understand how their IP assets can allow them to gain a competitive advantage to drive growth. And of course, this all starts with awareness and education. So a very warm welcome to all our speakers and an extended thank you from CIPO for offering your expertise to our audience today. I'll start off by providing some context around defending your IP rights and then set the stage for our distinguished speakers. So we know that simply owning intellectual property is not enough to stop other people from using it without permission. While the Canadian Intellectual Property Office grants IP rights such as trademarks, patents, industrial designs, and copyright, It does not police granted IP rights or monitor the marketplace for potential infringement. And solving these types of conflicts regarding IP rights is often complex. And so it's generally recommended to seek the help of an IP professional, such as an IP agent or lawyer, before enforcing your IP rights. So one of the things that you need to do in order to establish infringement claims is first identify your intellectual property rights. So each type of IP right has different requirements to establish infringement. The first step is to identify the IP rights you own, which will guide your enforcement strategy. Now, CIPO has resources on its website and also at the end of this presentation that will help you identify the types of IP that you may hold and provides examples of infringement for each type of IP. Next, you need to identify the alleged infringers. It's important to identify all parties and locations involved in the infringing activity. So for example, a legal name, address, and these are factors that can significantly impact the time, cost, and manner of enforcing your rights. Collecting evidence. So you'll need evidence to support a valid claim, and this means that you'll need to prove which parts of your IP rights have been infringed by collecting and using evidence. You'll then you'll need to determine your enforcement strategy. So here are some strategies you could use to enforce your IP rights, either used alone or in combination. So providing a notice and or cease and desist letter, you may offer the infringer the option of licensing your IP. You may use the customs program. So we'll be hearing more of this CBSA program to help prevent counterfeit and pirated goods from entering Canada from our guest speakers. You can consider pursuing alternative dispute resolution options through a mediator or an arbitrator. Litigation is also an approach. And enforcement can also include requesting re-examination of existing IP rights. And again, we'll be hearing about these options from our colleagues at IPIC and the TMOB, so the Trademarks Opposition Board and the Patent Appeal Board. Ultimately, you'll need to weigh the costs versus the potential benefits of an infringement case before you embark on this journey. So with that, I will hand the floor over to our first guest speakers, Anna Lynn Forrest and Lauren Lipkiss, who will be speaking to us on CBSA's Intellectual Property Rights Program. So Anna, I will pass the floor on to you.
Thank you, Nina. Hello, everyone. Thank you so much. Hello, everyone. Hope you're all well. Welcome, and thank you for taking the time to attend this session today. It is my pleasure to provide you with some information about the Canada Border Services Agency's Intellectual Property Rights Program. The CBSA's role actually begins once a rights holder has completed and submitted a request for assistance. Prior to completing this request, ensure that your trademark or geographical indication is registered with the Canadian Intellectual Property Office and that all your information is up to date. Although copyrights are not required to be registered, it is strongly recommended. Once your form is completed, submit it to the CBSA for processing. When your application has been processed, the CBSA will send you a confirmation email. As you're completing your RFA application, keep in mind that this is your opportunity to provide the CBSA with as much information as possible. For example, you could provide comparisons of counterfeited against authentic items, or provide a list of indicators which an officer could then reference when they encounter a possible counterfeit good. It should be noted that when a shipment is intercepted, the CBSA will first assess whether or not the shipment presents any health, safety, or security concerns. To this end, shipments are referred to Health Canada and or the Royal Canadian Mounted Police. If one of these agencies wishes to pursue a case, then the shipment is not processed under CBSA's IPR regime. Rights holders can provide the CBSA with information about a dangerous goods shipment that they suspect is counterfeit via the Border Watch line. When a suspect shipment is encountered and once it has been determined that the shipment will be processed under the IPR program, the CBSA will verify that the rights holder has filed an RFA. They can also provide the rights holder with a sample of the goods, along with all the relevant information they would require in order to pursue civil remedy and ensure that the goods do not enter the Canadian market. Suspect counterfeit goods or pirated goods will continue to be detained by the CBSA until the conclusion of the proceedings. If the rights holder advises they do not wish to pursue legal remedy, the goods will be released to the importer. Alternatively, if the rights holder advises they do wish to pursue legal remedy, the CBSA will detain the goods until a court order or an out-of-goods settlement by way of a letter of undertaking is received, at which point the goods are destroyed by CBSA or delivered to the rights holder. Since the CBSA implemented the IPR program, many rights holders have decided to participate and filed their requests for assistance. The CBSA's role doesn't begin until this step has been completed, so I encourage all rights holders to submit their requests, especially as there's no cost to do so. In addition, historically, the majority of IPR cases have been settled out of court with little to no cost for the right holder. Lastly, if the CBSA contacts you regarding an interception, I encourage you, regardless of how big or small this interception may be, to move forward with protecting your rights. This will keep counterfeit goods out of the hands of Canadians and let these importers know how important protecting your rights are to you.
Thank you very much, Anna. That was a great introduction to a fantastic program, and I think that everyone should know that the program that's been instituted by the government through CBSA is working very well. And I hope that I can give you some tips on how it can be very effective to protect intellectual property rights. On this screen here, I have the actual form that is used by CBSA. And what happens in practice is you download this form, you fill it out, it takes very little time. And through organizations like the Canadian Anti-Counterfeiting Network and even some lawyers are actually assisting brands in completing this RFA form without charge. So not only is Anna's program not getting paid any money through the filing of these documents, but neither are professionals necessarily getting paid to assist in filing these documents. And the document itself is very simple. It's information that everybody knows, although there are a few tips that I think you should be aware of. For example, they ask you if you're going to file a bond, and that can scare some people. You don't need to file a bond. You just don't tick that box. And you also have a great opportunity to go ahead and file additional information on the form. You can file a manual that you may have which differentiates between or shows you how to differentiate between authentic and counterfeit product, what tips to follow, whether there's any cheat sheets. Some practical tips on how the program runs is as follows. As soon as there is a detention of any kind or a suspicious or suspected importation of product that is potentially counterfeit, you receive a notice from CBSA, and then you have 3 days from when you can identify that product as being counterfeit or not before you decide whether you want to go ahead or not. And that was something that was given to the brands after they started using the program. So you have 3 days and you can mull about and decide what to do. You know who imported it. And if you want to pursue a civil remedy, your clock starts ticking. The moment you say, yes, I do, and that could be because you've seen images of the product, and in well over 95% of the cases, you can determine whether the product is counterfeit or not by looking at those images. You then have another 10 days after a notice is given by customs. And as soon as they give that notice, you have to decide whether you want to do something within that 10 days. If you resolve the matter, and I would say well over 90% of the cases get resolved within this 10-day time period. If it doesn't, and you want customs to continue detaining the goods, well then you have to institute a legal action. That rarely occurs because importers have been not only agreeing not to allow that importation, but they've been agreeing to pay the cost of destruction and the cost of storage of the counterfeit products. So that's a win-win for the brand owner. So if you look at the cost of what we thought it was going to be before we started instituting the action, the cost potential actually scared away a lot of brands from filing their RFAs. But we now know that it costs next to nothing. And as I said, in well over 90 to 95% of the cases, it's the importer that's paying the cost. And not only that, you can get, as of May of last year, you can ask for an expedited examination if you have to. So there's some advantages to going ahead with the program. There's lots of reasons why you should file and very few that you should not. If nobody responds on the brand side, CBSA has no choice but to release the goods. And that, of course, is not a good thing. So you want to make sure that you respond to CBSA immediately. I also wanted to illustrate just by one small case study how this program can be so effective. And this is just one example of many. There was a shipment. It was detained by CBSA in the Prairie region, being Western Canada. There was a total of just 75 counterfeit luxury apparel items of all different kinds, representing 3 different brands, who all filed their RFAs. The importer was served immediately with a cease and desist letter by each of the 3 brands. We got notification of this product being imported, and we immediately conducted some searches and went ahead and tried to find this importer. The good news is the importer responded immediately, wanting to settle without proceeding to court. Not unusual, as I've said before. They immediately provided information implicating the exporter from the Philippines. They gave the exporter's bank account information. They gave, and we found images of the counterfeits that they purchased, and open source searches revealed that this exporter belonged to a Facebook profile that was associated with a Facebook group of about 1,400 followers. So by having an online investigator go and take a look through open source searching, we were able to find out that this was now a bigger operation than $200 worth of product. In fact, we went ahead and reviewed all of the posts we could find and contact information. It led us to a Facebook group with over 65,000 members in the US. Amazing, absolutely, for an incredible result. The Facebook connections were all terminated. And at the present time, because this is a recent case, there are further investigations which will lead to enforcement being conducted in other countries. So this $200 case in Canada has resulted in the termination of counterfeiting of a major international illegal operation. So I urge everybody, if you know a brand, if you are a brand, if you have rights, intellectual property rights, trademarks that are filed in Canada, or copyrights that exist, file your RFA. And subject to any questions, those are our comments. Thank you.
Thank you so much, Lauren and Anna. That was a great overview of the program, the IPR program, and just that case study at the end just really shows the practicality, like all that theory sort of in practice, and how what impact just filing an RFA would have on a business's brand, and product. So thank you for that. That was very interesting. So on to our next speakers, Yves Hippy and Marcel Brisebois, who will speak to us on advisory boards within CIPO for trademarks and patents. So first I'll pass the floor on to Yves. Thank you, Yves. Yes, over to you.
Thank you very much. So yes, my name is Yves Hippy, and I am a hearing officer at the Trademarks Opposition Board. I'm here to quickly present the board, or as it's sometimes referred to, the TMOB, and the work that we do. So to begin, the board is a body within CIPO, and members and hearing officers of the board act on behalf of the Registrar of Trademarks. The board operates actually at two specific moments in the lifespan of a trademark. So I'm just going to switch to the new slide. And so here is the lifespan of a trademark. And the board actually will operate at two moments, as I mentioned. The first time is after step 7, which is the advertisement of an applied for mark. So the procedure that can happen after advertisement is an opposition proceeding. So as I mentioned, these proceedings take place before registration of a mark, and a successful opposition would prevent a trademark application from issuing to registration. The second moment that the board will operate is after registration, and specifically 3 years after the registration of a trademark. At this point, a party can request that this registration be removed from the register, and these proceedings are called summary expungement proceedings. So again, these proceedings take place after the registration of the trademark, and a successful expungement proceeding would remove the registration from the Register of Trademarks. And this would be done for failure to provide sufficient evidence that the trademark is actually in use. So just quickly then, who can file proceedings before the board? Essentially, any party can initiate both types of proceedings. And of course, these proceedings would typically be initiated by parties which have a particular interest in doing so. So in the case of an opposition proceeding, it would be to prevent the registration of a trademark, or in the case of expungement proceedings, the interest would be in clearing the register of a particular trademark registration. One good example of a party who would have an interest is because they have filed, for instance, a trademark application that is similar to one of the two marks that is either pending or registered. So how would you know if one of these proceedings has been filed against your application or registration? Well, first, the registrar will send you a notice by mail, and if you have appointed a trademark agent, then the registrar will also send a courtesy copy to your agent. So your agent would typically then contact you as well to let you know of what is going on. And the third way is the Canadian Trademarks Database, which is a publicly accessible online database which contains all of the applications and registrations which are pending and active. Even the inactive ones are there. So if you have an application or a registration for a mark, then you can go on that publicly accessible database and see whether such proceedings have been filed. So I also just wanted to go through some very quick stats about the board and our proceedings to give you an idea. These are numbers per month. On average. So there are about 6,000 trademark applications filed in Canada every month. And of those 6,000 applications, there are about 50 opposition proceedings that are initiated. And we have about the same number, so same 50 Section 45 notices that are initiated against registered trademarks. And this last number here, the 30 automatic expungements, Well, those are expungements of registrations that we say are automatic. They're not exactly automatic, but those are the cases where the owner simply does not file any evidence at all. They just choose not to respond to the notice, in which case the registration will be expunged without decision. And so just to conclude, the board does want to explain that it cannot provide any legal or substantive advice. So the board is a quasi-judicial tribunal and therefore cannot comment on the merits of a case before issuing its decision. These are pretty complex proceedings. They can become quite complex depending on the parties. And so we always encourage that parties seek the representation of a trademark agent to assist them. Otherwise, the board does have some helpful resources on its website, and I believe the links will be included in the last slides of this presentation. In particular, there are some FAQ sections about both types of proceedings, as well as practice notices, which give additional information.
Thank you. Thank you. Thank you so much, Eve. Yeah, so we have provided some of those links at the end of the presentation, as well as in the chat. So I'll now pass the floor on to Marcel, who will be speaking about re-examination and the Patent Appeal Board. Marcel?
Well, yes, my name is Marcel Brisebois. I'm a member of the Patent Appeal Board at CIPO, and I'm here today to present you a short overview of re-examination, which is a procedure before CIPO, which can result in canceling any claim, confirming any claim, or modifying, adding any claim off to an issued patent. So re-examination can maintain or reduce the scope of protection of a patent, but it cannot enlarge it. The first step is a request for re-examination that can be made by anyone, including the patentee. The request must be based on prior art consisting of patents, patent applications, or printed publications. Importantly, the request must explain the pertinency of the prior art and how to apply it. And finally, a fee must be paid, about $2,000. Once the request is deemed valid and the fee has been paid, a re-examination board will be constituted. It's composed of 3 members, a chairperson from the Patent Appeal Board, and 2 patent examiners from a division that is relevant to the subject matter of the patent under re-examination. The first step for the re-examination board is to determine if there's a substantial new question of patentability that is raised by the request. New here is an important word because any issue that has been already dealt previously during regular examination cannot be the subject of re-examination. So if the answer is no, there's no substantial new question of patentability raised by the request, the re-exam board will notify the requester, and that will end the process. The decision is final, no appeal possible. On the other hand, if the re-exam board is of the view that the request raises a substantial new question of patentability, it will notify the patentee and invite the patentee to reply. Typically, the patentee will reply, and that will start the re-examination proceedings per se. That must be completed within 12 months. During those months, multiple exchanges between the patentee and the re-exam board will occur. The patentee will provide arguments as to why the claims are fine, or propose amendments, new claims that will address the issues identified by the re-exam board. Then finally, completion of the re-examination with a certificate of re-examination. So only the patentee has the right of appeal to federal court at the end of the re-examination process. The appeal must be taken within 3 months from the date that a copy of the certificate of re-examination is sent by registered mail to the patentee. And from the standpoint of a third party, Re-examination provides a relatively summary and expensive alternative to an impeachment process, although it is restricted to prior art issues. And from the standpoint of a patentee, it provides an opportunity to have the patent office reconsider the claims of an issued patent if the validity of some claims is in doubt, for example, after the discovery of new prior documents. Quick statistics: about 80% of the requests for re-examination are filed by a third party, about 20% by the patentee. And with regard to the fields of technology that are the most susceptible to receive a request for re-examination, the field of mechanical engineering is receiving much more requests for re-examination than other fields such as biotechnology, chemical engineering, or electrical engineering. That's it for me today. Back to you, Nina.
Thank you. Thanks so much, Marcel and Yves, for providing those insights to those advisory boards. So finally, we'll move on to James Plotkin. So he'll be here James will discuss ways to enforce your IP rights through litigation, ADR, and other legal avenues. So James, I'll pass the floor on to you. Thank you. And James, I'm sorry, yes, perfect. I can see you now. Excellent.
Great. Just want to make sure I got the camera on. So, well, everybody, thanks again, Nina and everybody for joining us today. I'll be discussing a little bit about IP rights enforcement, and I plan on covering very broadly three broad topics, and we could probably spend an hour or two on each of these if we had the time. But from a 20,000-foot perspective, we'll touch on what to do when you're the target of an alleged infringement claim, so either a defendant or a soon-to-be or potential defendant. Then we'll talk a bit about the litigation process from more of a neutral perspective, not specifically from a plaintiff or defendant perspective. And then last, I'll address alternative dispute resolution, specifically mediation, arbitration, and a couple other forms of ADR. So first, what happens when you're the target of an alleged infringement claim? So this ordinarily begins with a letter, and the letter comes in one of two flavors or both, either a cease and desist, which is basically saying, well, you're doing something that's infringing upon my rights, stop doing it or else, and also sometimes comes with a demand. So in addition to ceasing whatever activity the plaintiff or would-be plaintiff says is infringing their rights, it might even come with a demand for a remedy, something in the nature of injunctive relief, which we'll talk about a little bit in a couple minutes, or even a claim for damages. So the first thing that's really important is to take these letters seriously. And this is because the IP statutes in Canada, the Copyright Act, Trademarks Act, Patent Act, and other statutes offer a pretty powerful suite of remedies to plaintiffs who complain of copyright infringement. And so ignoring a letter of this nature is generally a bad strategy, because this could actually even play into the remedy and the outcome in the litigation. And just to give one example of this, in the case of, just to say, copyright infringement, the Copyright Act provides what's called statutory damages to a successful copyright infringement plaintiff as a potential remedy. And what this means is that rather than proving the specific loss, the court will award damages to the plaintiff within a preset range under the Act. And one of the criteria that the court will consider in determining how much or how little to award in damages is the conduct, both the pre and during litigation conduct of the parties, including the defendant. So ignoring a letter is probably something that would go against you in an analysis like that. The next step, and this is really critically important, is to seek legal advice. And it's important to do this before responding to the letter. And that's because saying the wrong thing or failing to say the right thing in a letter can actually exacerbate the situation, can make things worse. And so it's important to consult counsel in advance of responding, but of course not to wait too long in doing so. And another important thing to mention here is that unlike some areas of law, general civil litigation, real estate matters, intellectual property is a fairly specialized area. And even within IP, there are subspecialties. So for instance, my practice covers copyright, trademark, and domain name disputes. I don't do patent litigation at all. So if somebody came to me who's notionally an IP lawyer with a patent dispute, I would refer you to a more specialized patent lawyer. So it's important to make sure that you're in front of, of the right person when you have these issues come about. So what you want to then determine is what rights the complainant or plaintiff says they have. And, you know, in letters like this, because this is the first shot that's fired in a litigation or potential litigation, the plaintiff tends to put their rights at their highest, and in my experience, sometimes even asserts rights that they don't necessarily have. That's with maybe a little bit of wishful thinking. And so it's important not to panic when you receive this letter, but again, to take it seriously. And when you do consult a qualified IP professional, they'll be able to parse out for you the various statements and allegations in the letter, explain what is serious, needs to be addressed, what's maybe some puffery, what's some posturing, and that's the sort of thing that you'll go through with your counsel once you analyze the letter. And finally, on this point, what remedies are they seeking? So I talked a little bit before about injunctions. There are all sorts of different kinds of remedies in IP disputes, but the main ones that we see are injunctions, which is a court order to either do something or not do something. In the broadest sense, that's what an injunction is. And if you fail to obey the order, you're in contempt of court. The other common remedies are damages, which is basically a remedy that allows the plaintiff to recover funds or money representing their losses that arise from the infringement. And then the other side of that coin is what's called an accounting of profits, whereby the plaintiff recovers the defendant's profits that it garnered or earned as a result of the infringement. There are other remedies like destruction, delivery up of property, and other such things, but those are the three main ones, and those are the ones that you'll often see discussed in these lawyers' letters. So what's next? Once you have the letter, you have counsel, the next thing to do is to gather the facts and the evidence that relate to the claim, that relate to the allegations in the letter. And it's very, very important, and you know, small businesses, individuals don't necessarily implicitly think about this, but it's very important as soon as you're put on notice about potential litigation to retain and preserve anything that could be relevant to the litigation. And this is because of obligations to disclose relevant documents in the litigation process. And that takes different forms in different courts and venues across the country and in different litigation processes. But as a general matter, number one, don't destroy anything relevant, but also make sure that you retain and don't inadvertently lose or delete or otherwise lose track of important material. Again, here I say react promptly. This is, you know, goes to what I was saying before. The longer you wait, the more you procrastinate, the worse the potential outcome could be. And again, you know, sometimes these letters are sent and they're just a shot in the dark and nothing ends up happening, but it's a pretty risky proposition to bank on that in most cases. And so promptness is generally a good policy. Again, we discussed before, seeking legal advice before formally responding for the reasons that I suggested earlier. And when you do respond, how do you respond? Now, this is again something that you want to determine in consultation with your counsel, but in some instances it makes sense to provide just a strong denial. You know, I haven't infringed your rights, you don't have rights, or the rights that you have don't overlap with anything that I've done. You know, essentially take a hike. In other cases, it's actually a lot more advantageous to think through whether what the complainant or rights holder is asking for can actually be accommodated fairly painlessly. So for example, I've seen instances in my practice where someone is accused of trademark infringement or passing off, but the businesses really don't operate in the same area. And the real concern on the plaintiff's part is to not, you know, dilute the trademark rights, to lose distinctiveness in the trademarks and therefore actually put their own rights in peril. So this could sometimes be remediated through licensing agreements, you know, coexistence agreements. There are creative solutions that you can sometimes get to if the parties are appropriately minded and the situation warrants it. And so there isn't really a one-size-fits-all way of responding to these letters, but again, with your counsel, you'll be able to determine the most effective way to do so. So turning to our second broad topic, litigation. So just to take a step back for a moment, when it comes to resolving disputes, there are, broadly speaking, two ways of doing so. Litigation before the courts, and we'll talk about those courts in a second, and ADR, which we'll get to afterwards. So when you're litigating before the courts, either as a plaintiff or a defendant, you have to choose which court to go to. And in Canada, and this is something of an oversimplification, but in Canada, there are broadly two choices. There's the federal court, and the provincial superior courts. And which one you choose will, again, depend on the nature of the dispute, the location of the parties, the location of any property in issue, and also the relief, if you're the plaintiff, the relief that you're seeking, and a couple other considerations that we'll talk about now. So dealing first with the federal court, one major advantage of litigating in the federal court is that it is a court for all of Canada. It sits across the country in different cities and at different times. The judges often rotate throughout the different regions. It's based in Ottawa, but again, the court is known as what's called a wandering court. So it sits all over the country. There is that level of convenience. And orders of the federal court are immediately enforceable throughout Canada, which is not the case of a provincial superior court judgment. So for instance, if you obtain a judgment in Ontario from the Ontario Superior Court of Justice and you want to enforce that judgment in, say, Alberta, you can do so, and there are processes for doing so, but you don't have immediate judgment. The judgment doesn't have immediate effect, I should say, outside of the territory of the province. And so that could be a relevant consideration, in particular, where the infringement crosses provincial lines. Another benefit that's often touted about the federal court is that it has more of a specialized IP bench. Not all of the judges, but there are a significant proportion of judges on the federal court that have significant experience in various areas of IP, as opposed to the provincial superior courts, in which, although it's possible to get a judge who has strong knowledge of IP, is less likely just because of the much broader jurisdiction of the superior courts. I mean, these judges hear everything from criminal matters to family matters to complex commercial litigation. So you have a better chance of getting a specialized judge in the federal courts. Now, with the provincial courts, as I said, the order has effect only within the province, although there is legislation in place in all of the common law provinces and territories, so basically everywhere in Canada except Quebec, that allows for fairly easy and efficient reciprocal enforcement of judgments in different provinces. So the fact that you're starting your claim in a provincial court doesn't mean that you can't enforce it outside the province. It just means that there's one additional step to do so. Commencing in the provincial courts could be more advantageous when, for instance, the dispute is more local, is more locally focused, and also, even though a lot of the jurisprudence, the legal tests that come out with respect to the remedies available, like injunctions, come from the Supreme Court of Canada, different courts interpret these tests different ways. And so, just to speak about injunctions, it's generally considered to be easier to obtain an injunction in an IP case in the courts of Quebec or British Columbia, just because of the way that those courts interpret the injunction analysis versus the way the federal court or the Ontario courts, for example, have done so. And before leaving this topic, there's one other, I think, fairly important practical consideration to think about when you're determining where to make a claim. And this is the question of cost recovery. So the different courts in Canada have different regimes on cost shifting, who pays the costs in a litigation. So on one end of the spectrum, you have the province of Quebec, where counsel's fees, lawyers' fees are not recoverable basically at all. So each party will more or less bear all of their own costs, except for in exceptional circumstances. On the other end of the spectrum, you have the province of Ontario, where parties can recover anywhere between 60 to 100% in some instances of their legal fees and also their disbursements. And so that's a pretty radical difference from Quebec. And the federal court sits somewhere in the middle, where you can recover some costs, but generally not as much as in Ontario, but certainly more than one can recover it before the courts of Quebec. And so if cost recovery is an important consideration, that's something that you will want to discuss with your counsel in advance of starting a claim. Turning to our final topic, alternative dispute resolution, close to my heart, as I'm an arbitration person. ADR is, in its most general sense, a method of resolving disputes, again, without litigating before the courts, which doesn't mean without court involvement, but without actually going to trial or a hearing and getting a judgment from a court. And there are three general categories of ADR: contentious or quasi-judicial ADR, like arbitration; non-contentious, mediation and negotiation; and hybrid, early neutral determination is an example of that. So to begin with arbitration, this is, again, almost like a private court process. And we'll talk about some of the benefits of arbitration in a moment, but it's an adversarial process where, again, usually you're represented by counsel, There will be pleadings, there will be evidence, there will be arguments, and at the end of the day, you get what's called an award, which is tantamount to a judgment in order in the courts. And through various arbitration legislation throughout the country, arbitral awards are enforceable fairly easily and painlessly, and can become orders of the court and have basically all of the executory power of a court judgment in fairly short order once they're rendered. For the non-contentious negotiation, I won't spend too much time talking about. We all understand, conceptually what negotiation is. Mediation is a conciliatory form of dispute resolution that is non-contentious in the sense that the mediator, the neutral, impartial expert, is not there to actually adjudicate the claim, say who's right or wrong, but to try to act as an impartial and objective intermediary to help the parties reach a settlement. And there are a couple different mediation styles. One is, again, more conciliatory, just trying to facilitate the conversation, whereas some mediators apply more of what we call an evaluative approach, which is stopping short of rendering judgment or saying with certainty what the outcome would be, but would be more in the nature of pointing out the strengths and weaknesses to each party about their case in the hopes of making them understand their case better and maybe move towards a resolution. Early neutral determination, again, is somewhere in between. So this is when you have, again, a neutral, independent person give their opinion, give a more formal evaluation following the receipt of submissions and evidence, kind of like an arbitration, except the outcome is not binding. So it can't be enforced in a court. It's there to really give the parties a clear evaluation, usually by a senior and expert member of the bar or somebody with relevant expertise who can really engage in what we call real talk with the parties. So some of the benefits of ADR. When done right, arbitration, mediation, early neutral determination can be very quick, which means saving money, saving time, saving stress. Efficiencies can also generally be achieved. And so if you're in an adversarial process like arbitration, it's not necessary to arbitrate with all of the heavy machinery of the courts, discoveries and live witnesses and all these things that we see in the rules of court. The benefits of arbitration over court is that it allows a lot more flexibility and informality in the dispute resolution process. And the key principle of arbitration law is party autonomy. In other words, the parties, subject to very few limitations, are free to design the arbitration process that's right for them and right for their dispute. Another big benefit of ADR more generally, not just arbitration, but also mediation and others, is privacy and confidentiality. So privacy, and just to distinguish those two, privacy is the notion that the hearing or the mediation is private. It's not open to the public, unlike courts in Canada where you have the open court principle. Anybody can walk in to almost any hearing and watch. Arbitrations are private, so there's no presumptive right of the public to attend or to have the information. Confidentiality is something slightly different. It actually renders sometimes even the existence of the arbitration or the proceeding, but certainly any of the content filed and the award confidential, such that the parties, the arbitrator, any other actors or players in the arbitration cannot disclose or otherwise disseminate the information. And this can be particularly useful in IP cases where you have sensitive commercial information, trade secrets cases, or sales volume, when you want to prove damages or accounting of profits. Oftentimes sensitive financial information can come to play, and so confidentiality is a really great tool there. As I said, there's a potential for lower costs. This doesn't always happen. I'm involved in an arbitration right now that's in its 13th year, if you'll believe it, which is a little crazy, but that's definitely not the norm and not representative of most arbitrations I've been involved in. Usually, in particular, where you have a good arbitrator or panel of arbitrators and experienced counsel, these things tend to run very smoothly. And even though you're actually paying your decision maker, can end up significantly less costly than court litigation. Finality is another really important consideration here, because in arbitration in particular, it's possible to either exclude rights of appeal, or in particular in international arbitrations, there are no rights of appeal even in the first place. And so you can win a trial in court, and then you can have an appeal, and sometimes 2 levels of appeal, in certain instances even 3 levels of appeal, all the way up to the Supreme Court of Canada. And it could take years and years to finally resolve a dispute. Parties to an arbitration agreement can just cut all that out and prevent any appeals on the merits of the award. So that can, again, help, in particular when you have ongoing business relationships. You don't want to be spending a decade in court. Could be a very valuable tool. And that again brings me to the final point. There's generally, and this is a generalization, a better chance of maintaining ongoing business relationships when you use non-contentious means of ADR like mediation and negotiation, and frankly even arbitrations. Sometimes if they're done quickly and painlessly to deal with, for example, in a question of IP rights ownership, who owns the copyright, who owns the patent in this invention. This can often be done in such a way so as to make things less acrimonious, no airing of dirty laundry in public, and that could be a useful tool in IP disputes as well. So the last point here is, again, I mentioned at the beginning that ADR means no court judgment, but it doesn't necessarily mean no court. So traditionally, ADR is done out of court, and the typical mediations and arbitrations are done out of court. And you'll see here the third bullet, med-arb, which refers to mediation/arbitration. This is a hybrid where you have the same neutral acting first as a mediator, and then if the matter can't be settled in mediation, puts on the arbitrator hat and adjudicates the dispute. And again, that's worthy of a presentation in and of itself, but that can also sometimes be a very valuable and useful tool. And on the other hand, you do have some manners of court-assisted ADR, and specifically in the federal court, which can sometimes be very useful, is the court-assisted mediation program. And there, you'll have usually a prothonotary of the federal court, or sometimes a judge, act as a mediator if the parties agree to enact this process under the rules, and they'll perform the role of a mediator just like a private mediator would. The benefit is that it's well, I don't want to say free, but certainly you don't have to pay the mediator. You don't have to pay the judge or prothonotary, so it could be more cost effective in that way. And the last thing is pretrial conferences, and there are different kinds of pretrial conferences, but in both the federal court and the superior court, before a matter gets heard, before a trial actually occurs and the hearing begins, there are all sorts of procedural issues that have to be dealt with in these pretrial conferences, and oftentimes the pretrial conference will also be used almost like an early neutral determination, whereby the pretrial judge will, again, speak frankly to the parties about the strengths and weaknesses about their cases and make one last attempt to have them resolve their dispute without invoking the machinery of a trial. And so those are the various forms of alternative dispute resolution. And with that, I conclude my presentation. Thank you.
Fantastic. Thank you. Thank you so much, James, on providing an overview of those few legal enforcement approaches, especially the ADR. I learned a lot. And so I'd also like to thank all of our speakers for providing insights on defending IP rights from your different areas of expertise. So this concludes our last session of the IP Talk series. So thank you again to our esteemed panelists for such an engaging session, and to our audience for taking the time to attend.